Hi, my name's Catherine Corfey of Corfey Stone Law Corporation. And I wanted to touch bases with you a little bit about the ADA. There is so much going on. Many of these disabled plaintiffs are routinely filing massive lawsuits, and it's not fair. And they simply just drive by your property with no intention of enjoying their goods and services. And then they sue you for minor infractions, or maybe they have something legitimate because you have a step. Basically, what they end up suing you over is two claims. One is called the ADA. That's the federal law. That was enacted by Congress. That's the Americans with Disabilities Act. And that was enacted in 1992, and there's a set of codes and regulations that basically require you to have a door at 32 inches or have a van accessible parking if you happen to offer parking. And the only remedy that a disabled person can get is a court ordering you to fix it. So if you fix it voluntarily and permanently and have no plans to ever change it back, you can actually moot that claim and dismiss it. And that's important because you never want a court to order you to fix something, because that means the plaintiff prevails and then they get attorney's fees. So a lot of times these cases are driven by attorney's fees. Now, the other claim that they allege typically is the California Unruh Act, and that's where a plaintiff actually gets statutory damages. All he has to prove is that he's disabled, he went there, and there were barriers. Barriers meaning you didn't meet the ADA code. Now, there's other claims they can bring, but these are the two most prominent claims that they bring. And so what a plaintiff can recover under that law is $4,000 per visit. That's right. If they go one or two times, they can get potentially more. Now, there is an awareness by our legislator that knows that they could possibly stack their damages. So there's also another law that says a plaintiff has a duty to mitigate his damages. He can't just keep returning, putting himself in harm's way without informing the landlord or the tenant about the barrier. So technically they can only have one visit of $4,000, although they'll claim more, and then you usually have to fight them on the other additional reasons. Now, if they return multiple times and have a very good reason, like they have to go to a hospital or they belong to a disabled community and club that meets every Tuesday, say at a pizza parlor, that is a legitimate reason. Or it's the only hotel in town and they go there to care for someone. I've seen that in the cases. And then they could get more than $4,000. But they also get their attorney's fees. So these cases can be driven by opposing counsel wanting to drag the case out and recover money. I mean, generally they have rates as high as $500 an hour, and so you will be charged for that in a settlement. They pretty much demand that. So the best thing that you can do is to avoid one of these lawsuits. You can hire what's called a CASP. That's C-A-S-P. It's a California Access Specialist. Now, when you hire a CASP, be careful. Make sure you hire a CASP under the direction of an attorney, because when they come out and do a full-scale inspection of your property, that could be discoverable, and you don't want opposing counsel or a potential plaintiff to see it, because they just use it against you and they can amend the complaint and add all these barriers that they didn't otherwise know. Now, if an attorney directs this CASP inspection, then it is privileged under the attorney-consultant privilege. Now, if you are sued and there's a lawsuit, I know a lot of you want to go out and fix it, and that's the right thing to do. So when you have the CASP, just make sure that your CASP is only inspecting what is specifically alleged in the complaint, because there's going to be vague allegations based on information and belief, but you just want that short report, and then the full scale can come through basically your attorney. So in the end, these cases are very expensive. You have to pay the fix-it cost, you have to pay your attorney, and then you have to pay the other side. And our firm has been able to prevail. We filed legal briefs and motions, and we have won, and we have gone the distance. There's also a defense that a plaintiff is a vexatious litigant, meaning he's basically going around and suing to extort early settlements, and he's harassing you. And that's a very difficult motion to bring because it would otherwise quell their civil rights, which the law is noble because we want the disabled to have access, but basically it's being abused by a few who don't really care about your goods and services, like the non-disabled. So it's not really comparing apples to apples. And the abuse is where you would want to file a vexatious litigant motion. But again, you have to be cautious. They're not always won, and they're difficult to win. You have to cull all the information and show that this person is truly harassing. All right, well, I hope that helps because there's a lot of confusion about this law. And if you have any questions, you can always contact our firm. We provide pre-litigation advice and obviously defend in litigation. Thank you.